Would you mind? Great. Welcome, everybody. Thank you for joining us to the Academic Freedom School, Defending Academic Freedom in Florida, which is the first of four panels that are going to run through February. Kate Taylor will put in a flyer at the end of the session of the upcoming panels, but keep an eye out for those on topics about countries of concern, issues about gag orders in the classroom, and faculty being sanctioned for their extramural speech, especially around the issues of Palestine. Those three other panels are forthcoming. But this idea of academic freedom school comes from conversations. Well, first of all, it's co-sponsored with the Center for the Defense of Academic Freedom, which is a new project at the AAUP that I'll talk about in just a second. It's co-sponsored with the Center for the Defense of Academic Freedom and United Faculty of Florida, FIU, and UFFC, UCF. The Center for the Defense of Academic Freedom is located at the American Association of University Professors and exists as a center that provides resources and support for faculty, staff, administrators, journalists, students, alumni, parents, politicians who want to push back against the attacks on academic freedom that are coming from an increasing a number of directions, from state legislators and governors, as you know, in Florida, but also from online trolls from international sources, lawfare, and elsewhere. So as the threats to academic freedom evolve, the Center for the Defense of Academic Freedom has become a project to think through those evolving threats. We have 15 fellows, including one Professor Tim Kaine, who is going to moderate this event. So that's a background. The panel came, or the idea of the Academic Freedom School came together in conversations with Katie Rainwater at FIU and Robert Casanello at University of Central Florida. And the idea was to create a space to talk about issues that are of importance to faculty in Florida as they try to navigate these difficult waters, and to hopefully serve as an organizing opportunity. So we're recording this event tonight. We'll also be creating a one-pager about post-tenure review and taking the words of wisdom that come out of this event and turn it into a series of kind of guidance in order to support your work and your organizing. And it goes without saying, please consider the center an ally in this fight and reach out with any questions. We're happy to support any of the work that you're doing. So I'm now going to turn it over to Tim Kaine, who's the moderator. I'm really pleased to introduce Tim. He's a fellow at the Center for the Defense of Academic Freedom. He's been an absolute joy and pleasure to work with. I've learned so much about the history of academic freedom and about the history of higher education in general from him in the brief few months that we've been working together. Tim is a professor at the Louis McBeal Institute of Higher Education, where he teaches and studies issues related to faculty, campus activism, unionization, and the history of higher education. He's also the associate editor of the Review of Higher Education. And I'll turn it over to you, Tim, to introduce the rest of the panel. Thank you.
Thank you so much, Isaac. And believe me, I've learned a great deal from you in the past few months, and I look forward to our weekly meetings. I'm pleased to be on this panel, and I look forward to learning with all of you. I will, in just a moment, make a few framing comments, but I first want to introduce our two panelists. Jennifer Proffitt is a Theodore Clevenger Professor in Communication at Florida State University. She served as the president of the statewide United Faculty of Florida from 2015 to 2017, and is the president of the FSU chapter from 2013 to 2014. She has served as co-chief negotiator for the FSU chapter since 2022. Risa Leibowitz is a professor of labor and employment law in Cornell University's School of Industrial and Labor Relations, and is the academic director of the Worker Institute at Cornell. She was the general counsel of the American Association of University Professors from July 2014 through September 2024. She's a member of the National AAUP Committee on Academic Freedom and Tenure, and is the president of the Cornell University chapter of the AAUP. Welcome to you both. Today's conversation is, as you know, about collective bargaining, post-tenure review, and recent legislation in Florida. To get us started, I'm going to provide a very brief introduction to all three. Faculty unionization dates 1918. The first contract was signed almost 30 years later by Howard University faculty members in the United Public Workers CIO. The real era of faculty bargaining in higher education dates to the 1960s, as faculty turned to labor to help improve the conditions of their work. It then grew substantially in the 1970s. There were multiple drivers of this, but it was facilitated by the changes in state law that allowed for and facilitated public sector unionization, including in Florida, where faculty could bargain beginning in 1976. That led to the United Faculty of Florida the following year. By 1980, more than 20% of faculty in the country were covered by bargain contracts, but the growth slowed dramatically, both because of the Supreme Court's 1980 yeshiva decision limiting the ability of faculty at private colleges from bargaining, and the lack of new state laws expanding bargaining rights. Unionization in higher education writ large entered a new era in the 1990s with the increased activism for graduate student unions, and then a decade later with the organizing of what Rachel Levy has termed vital faculty: visitors, instructors, temporary adjuncts, and lecturers. The recent past has seen both a burgeoning in the higher education union movement, including undergraduates, graduates, and faculty, and also significant state-level efforts to undercut unions. Roughly 27% of faculty are covered by bargain contracts, and the enthusiasm is greater than it has been in 40 years. But as the Florida situation reveals, the backlash is tremendous and has the potential to be devastating. The early evidence on bargaining showed that many of the fears expressed by those who opposed were misguided. For example, bargaining did not damage shared governance, but bolstered it, and unions did not trade academic freedom for increased wages. For graduate students, it did not harm relations with faculty members, but improved them. There are some conflicting studies on salary benefits at four-year colleges, but overall compensation for faculty has increased through bargaining. Importantly, unions provide faculty with a voice in a period in which faculty voice has been diminished in the administrative university. Of course, bargaining is a process, it is hard, and it takes work. In Florida, there's not one overarching contract. Instead, university-level chapters bargain their own agreements, and they do so through the efforts of people like Jennifer Proffitt. Turning to post-tenure review, the tenure system as we know it in the United States rose in the mid-20th century. Some faculty had quote-unquote permanent positions, but there were no well-developed mechanisms for awarding it, and certainly defending it. In the early 1900s, faculty such as James McKean Cattell began arguing more strongly for tenure as a way to both protect academic freedom and to serve as a form of compensation that could attract qualified scholars to academic positions. These ideas were captured in the American Association of University Professors 1915 Declaration of Principles, and again in the 1940 statement, which the AAUP negotiated with the Association of American Colleges, now known as AACNU. The 1940 statement included, quote, tenure is a means to certain ends, specifically one, freedom of teaching and research, and of extramural activities, and two, a sufficient degree of economic security to make the profession attractive to men and women of ability. Freedom and economic security, hence tenure, are indispensable to the success of an institution in fulfilling its obligations to its students and society, end quote. And those last two pieces are important. It's about fulfilling obligations, allowing higher education to do the work it's been tasked with doing, not about personal rights or individual privileges. It was the endorsement of this statement and its widespread adoption by institutions after World War II that led to the modern tenure system, but by the late 1960s, it was under attack. Amid the activism of the period, some, including the Scranton Commission investigating the killings of students at Jackson State and Kent State, started to ask if faculty were the problem and advocated change in the tenure system merely 20 years after it was truly established. More than 20 states considered legislation that would have altered or ended tenure, and a few universities instituted post-tenure review in the early 1970s. A 1982 National Commission on Higher Education Issues, sponsored by the American Council on Education, called for post-tenure review. But the following year, a conference involving representatives of 10 higher education presidential agencies pushed back, arguing that it would be, at best, a waste of time and effort, and potentially far worse. It was in this context that the AAUP first argued against post-tenure review as, quote, weakening or undermining the principles of academic freedom. 16 years later, amid increasing attacks on tenure that threatened the very system, the AAUP again cautioned that post-tenure review was unnecessary and dangerous, but provided some guidelines on how it should be done if it were to be implemented. A study in the year 2000 showed that almost 46% of four-year colleges had a post-tenure review system, and a recent AAUP study using 2020 data found that 58% had such systems, almost half of which had mechanisms that could lead to faculty termination. These systems are more frequently found in public colleges, partly because of political and legislative pressures. A recent study by Barrett Taylor, who's a Center Fellow, and Kimberly Watts found that state legislators introduced 13 bills that would have outright banned tenure between 2012 and 2022, plus others that would have weakened it through post-tenure reviews. This issue is getting worse, as Isaac's manufactured backlash showed. Additionally, reporting this August in Inside Higher Ed indicated that in the last 2 years, at least 10 states have considered legislation either banning tenure or weakening it through provisions such as post-tenure review that could lead to termination. And of course, the efforts to undermine tenure, including through post-tenure review, can take place outside of state legislatures. Famously, the University System of Georgia, where I work, instituted a new annual review policy that allows any of the public universities to fire tenured faculty if they are found to be unsatisfactory in any category in which they're assessed in back-to-back years. That doesn't even have to be the same category. The AAUP took the almost unprecedented step of censuring the entire system, as this new policy violated all of its minimum standards for post-tenure review. That brings us to Florida and Senate Bill 7044, signed into law in 2022, and Senate Bill 266, signed into law this year. Senate Bill 7044 included, among other language aimed at deinstitutionalizing higher education, quote, the Board of Governors may adopt a regulation requiring each tenured state university faculty member to undergo a comprehensive post-tenure review every 5 years. SB 266 mirrored this language other than replacing may with shall. It also, though, took away the right to appeal beyond the university level for any adverse rulings in a tenure, promotion, disciplinary, or termination decision. In doing so, it eliminated arbitration in these matters. The laws themselves were damaging, but the way that the Board of Governors responded by including termination as a possible outcome was even more so, though it fits within a larger national pattern in which universities and systems overreact to legislative mandates and go further than was required. In this, the first year of its implementation, Politico has reported that 10 faculty were dismissed and that 60 others were put on remediation plans that could lead to dismissal next year. Other reports from the University of Florida indicate that in addition to those who were dismissed or put on remediation plans at the institution, 12% left during the review process, and others left the tenure track itself. These are sweeping attacks on the institution of tenure, on faculty rights, and on higher education more broadly. They're also an attack on both institutional autonomy and the historic regulatory triad that has assured accountability while protecting that autonomy. The concern is real, not just for those directly affected, but for what it means for faculty and for academic freedom in Florida writ large, especially as systems like these can be easily weaponized. As I hope you can see, there is a lot to talk about here, so I will now turn things over to Dr. Jennifer Proffitt, who will drill down into some of the details of what FSU faculty has bargained for and how UFF has challenged the implementation of these laws in relation to its contract. Jennifer?
Great, thank you so much. So I was told that I can get into the weeds, so I will, regarding post-tenure review in Florida and our experiences at FSU. So I'll start by briefly discussing, as Tim started to do, the legislation regarding post-tenure review, and then I'll talk about the Board of Governors regulation. I'll talk about our unfair labor practice, or ULP, that we filed against the Board of Governors and the Florida State University Board of Trustees. I'll also talk about the PERC hearing officer's recommendation, the full commission's decision to reject the hearing officer's recommendations, and our bargaining of PTR in light of the commission's decision. So, as Tim just noted, in 2022, the legislature added post-tenure review in Senate Bill 7044, but the addition actually said, and when we were arguing against it originally, said that the Board of Governors may adopt a post-tenure review process. Besides what Tim had read, it also says the board may include other considerations in the regulation, but the regulation must address, and it says 4 things: accomplishments and productivity, assigned duties in research, teaching, and service, performance metrics, evaluations, and ratings, and recognition and compensation considerations, as well as improvement plans and consequences for underperformance. Please note, it does not say fire faculty. Then in 2023, Senate Bill 266 changed the language from may to shall. In May of 2023, even after the Board of Governors received what I was told was an unprecedented number of comments regarding their hugely problematic proposal, it voted to pass it, which would make it easier for the administration to fire tenured faculty members. One problem, however, is that the regulation violated our collective bargaining agreement, including the tenure and evaluation articles. The FSU Board of Trustees ignored the violations, saying it was the law, and as such, they needed to pass a version of the Board of Governors regulation. So in May of 2023, the FSU Board of Trustees regulation was posted. We sent the administration a letter of clarification that made it clear that the regulation should not apply to in-unit tenured faculty because it hadn't been bargained. Our Vice President of Faculty Development and Advancement, who is on the Board of Trustees team, said that she understood that the implementation needed to be bargained. The BOT passed the regulation anyway, and then asked us a month later to impact bargain the policy the administration created based on the BOT regulation, which was based on the BOG regulation, not to bargain the regulation itself. We told them, no, this is not impact bargaining, and we should be bargaining the regulation, not the policy. So we specifically said the UFF does not agree that the law on post-tenure review can be implemented without bargaining several contract articles in the collective bargaining agreement. This is not impact bargaining, but bargaining a new process, not just the impact. It is unconstitutional for the legislature to impair a contract. The UFF position is that there's no obligation to engage in bargaining, and the contract is quite clear that neither party can be forced to bargain. 2 articles can be opened by the Board of Trustees next April as per the contract, and the entire contract can be negotiated in 2025. So this is what we sent them in 2023. Note that changes in tenure must also go through departmental review and not be implemented for a year after they are proposed. Changes in procedure for tenure are changes to the contract and must be bargained under existing articles. We also argued that the request to impact bargain the policy, not the regulation, was an abridgment of our constitutional rights, and that we weren't willing to take the first step to diminish the excellence or reputation of the university by being the ones to eliminate tenure. The administration interpreted what I just read as us waiving our rights to bargain, and they argued that they had to implement the regulation, it was law. Note, though, that we did not refuse to bargain. We refused to impact bargain, and we said we would bargain when it's time to bargain. Also note that the BOG regulation was not the law. We just heard what the law was. Despite our arguments, the administration started implementing post-tenure review without bargaining. In fact, we specifically noted that the Board of Governors regulation eliminated our ability to bargain over the post-tenure review evaluation procedure, which is a mandatory subject of bargaining. And as such, the Board of Governors regulation was invalid as applied to in-unit faculty. So that was one of our main arguments. I was asked to talk a bit about severability. It's not my expertise, but according to my understanding of the law, severability means if a provision of a contract is found by a court to be illegal, only that part of the contract is made invalid. At that point, impact bargaining of the invalidation of a portion of the collective bargaining agreement would occur. This would not affect the rest of the contract. But the thing is, we were arguing that the Board of Governors did not have the authority to unilaterally change our collective bargaining agreement, so severability wasn't an issue. The CBA clearly states that any regulation affecting terms and conditions of employment must be bargained, and it is the Board of Trustees' duty to bring it to the bargaining table, not the unions. So in August 2023, we sent a cease and desist letter that the administration ignored. And despite our misgivings and after talking to counsel, we did start bargaining, but not impact bargaining. We kept insisting this is regular bargaining. And we were bargaining a memorandum of agreement regarding a post-tenure review process. At the same time, the administration was already implementing the regulation and a policy that hadn't been bargained yet because they said they had to. And that is why we filed our unfair labor practice against the Board of Governors and the Board of Trustees. So, interestingly, the Board of Governors argued and actually were removed from the ULP because they argued that they were not the employer. We saw that in and of itself a problem that a group that's not our employer was forcing us to violate our constitutional rights and our CBA. Nonetheless, in December of 2023, a hearing was held. And in March 2024, the hearing officer agreed with us that, shockingly, in Florida, agreed with us that the FSU Board of Trustees committed an unfair labor practice by making unilateral changes to a mandatory subject of bargaining and recommended the that UFF's lawyers' fees be paid by the FSU BOT. We also argued that the administration engaged in direct dealing with the faculty by starting the process of PTR without bargaining it, but the hearing officer didn't agree with that charge. So the hearing officer agreed that evaluation systems are mandatory subjects of bargaining if they significantly and directly determine wages, hours, and terms and conditions of employment, which PTR clearly does. And that the only time they can is, and this is important, where there is a clear and unmistakable waiver of bargaining by the certified bargaining agent, which it wasn't, exigent circumstances requiring immediate action, legislative action taken pursuant to the statutory impasse procedures, or where financial urgency exists. So none of these were true. He ultimately recommended that the FSU Board of Trustees cease and desist, making unilateral changes to mandatory subjects of bargaining without first either engaging in collective bargaining or obtaining a clear waiver of bargaining from the certified bargaining agent, and B, in any like or related manner, interfering with, restraining, or coercing bargaining unit members in the exercise of any rights guaranteed to, under them under Chapter 447 of the Florida statutes. As you can imagine, we were absolutely thrilled with this recommendation. However, our elation was short-lived. In June, the PERC rejected the hearing officer's recommendation. It argued and a lot of things, but the main thing was that exigent circumstances mandated the FSU BOT to act immediately in order to comply with the law, because the BOG is constitutionally imbued with the authority to regulate and manage the whole university system, including the Florida State University Board of Trustees. So we reject this interpretation and have filed an appeal to the Florida District Court of Appeals. But of course, this process, the legal process takes a lot of time. So in the meantime, so from September of 2023 to March of 2024, we bargained post-tenure review memorandum of agreement, but we hadn't come to an agreement. Our major concerns were, one, that the Board of Governors stated that post-tenure review had to take into consideration, quote, the faculty members' noncompliance with state law, Board of Governors regulations, and university regulations and policies, end quote. So would that mean we could be fired for violating the now injuncted Stop Woke Act? How about running a red light, right? It's not clear what they were talking about, and it could be arbitrary. Two, post-tenure review would only be decided by 2 or 3 administrators without faculty input. 3, the criteria for the ratings were nonsensical. It said a clear and significant level of accomplishment beyond the average performance of faculty across the faculty members' discipline and unit. So we said, how do you determine what average performance even means? How do we compare across the unit, let alone across the discipline? So argued against that. 4, those who receive unsatisfactory would be terminated. And as such, of course, we are now on 5-year contracts, as there's no such thing as tenure in Florida. So our goal in bargaining was to mitigate the unclear language and criteria, to allow for faculty input in decision-making and in addressing the chair and dean's letters, tying termination to just cause as outlined in our collective bargaining agreement, and protecting academic freedom. Once regular bargaining started in April of 24 of this year, because PERC hadn't ruled yet, we kind of put PTR on the back burner. The Board of Trustees was insisting that post-tenure review be added to our evaluation article because they argued that PTR is not about tenure. They can take away your tenure, but it's not about tenure. We had convinced the Board of Governors team that a memorandum of agreement regarding PTR would be in all of our best interests. So there's not in the contract, because they knew that, it was going through the PERC process and it could be appealed and so on. But once the PERC ruled in the administration's favor, they told us on Friday they would do it. On Monday, that the decision came out Friday afternoon. Monday morning, first thing, I think it was like 8 o'clock in the morning, I got a call saying, we changed our minds. And said that we had to return to including post-tenure review in the collective bargaining agreement, that they would not agree to a MOA. In fact, their proposal right after the PERC decision simply said that the regulation would be followed. That's all it said. We went back to the memorandum of agreement we had bargained for 7 months. And let me tell you about what we did. So we added language stating, this is in the final article. We added language stating that if the statute or Board of Governors regulation is modified, overturned, or enjoined by a court of competent jurisdiction, the post-tenure review section of the CBA would be nullified. We thought that was really important to put that in because it's still going through the process. This is the reason why we didn't want to put it in the contract. So we thought it was important to put that language in. We added a reference to our academic freedom article. We said that in conducting post-tenure review, the university shall not consider or otherwise discriminate based on a faculty member's political or ideological view or properly disclosed and approved outside activities or field of study. And then again, like I said, linked it to our academic freedom and responsibility article. So we wanted to make sure, again, we're trying to cut out anything that could be quite arbitrary. We added clarity to the ratings and tied them to annual evaluation criteria relative to the academic unit's bylaws. Again, not average performance, whatever that means. The academic unit's bylaws and relative to the faculty members' AOR. Of course, the academic unit's bylaws are voted on by faculty. So we thought it was really important to tie it to that. For unsatisfactory, where they would terminate faculty, we added in evidence of failure to follow previous formal written feedback on performance or conduct, and evidence of performance that involves incompetence or misconduct, according to our discipline article 16. We clarified what would be in the binders, including annual evaluations and teaching evidence that included but was not limited to student perceptions of courses and instruction. We added that faculty shall be involved in the PTR process at the department level, and we tried to get it for the dean and the provost level, but agreed to that deans would be encouraged to include input from a faculty committee and that faculty members under review could include responses to the chair and dean letters. So another big concern that we had that I didn't mention before is that the Board of Governors regulation tied discipline to post-tenure review, or yeah, post-tenure review evaluations. And to us, that's double jeopardy, right? Punishing faculty again for an action that was already punished. The administration wouldn't budge on this, so we added language stating that responses to the chair and dean letters would include explanations, or could include explanations of disciplinary actions or negative evaluations, including timelines and any steps that were taken to improve. So while post-tenure review is still largely problematic as it can lead to termination, the PERC decision made it clear that we had to include language from the Board of Governors, the language that was adopted by the FSU Board of Trustees. So we did our best to find ways to make post-tenure review more palatable to faculty, reduce the ability for the administration to fire somebody arbitrarily, to protect academic freedom, and give faculty more say in the process. Thank you.
Great, thank you so much, Jennifer. Risa, I think you're going to help us step back to a slightly bigger perspective.
Yeah, thanks so much. Well, this is, this is a hard act to follow in various ways. I thank you, Tim and Jennifer, for your excellent remarks, and it's really good to be here. And thanks so much for asking me to be here. And Jennifer, the way in which you wove the strange tapestry that you're having to deal with was really enlightening, and I have to just thank you for all of the work and effort that you and everybody else with the union are putting into this, to fight such a difficult battle. So you have my thanks and my admiration. And what I'm going to try to do is to, as Tim said, step back a little bit and talk about how your remarks, as well as Tim's, kind of can get us to think about the situation. Just to start with, I think what we all know, but just to put it into that context, is thinking about this broader context of the corporatization, as it's been called, the corporatization of the universities, and the way in which the corporate model that's been put into effect, in particular, starting in the 1980s and getting much stronger in the 1990s and beyond, is this kind of corporate labor model, which is based on a vision of individual workers having no job security and basically being employed at will, and certainly very anti-union kind of model to keep that into effect. And that's what Florida and other states are trying to impose on us. And that's happening in the public and private sector universities, but it's certainly the weapon that's being used by a governor like DeSantis and legislators enables them to do this kind of really aggressive move in the public sector. And so, yes, there's a union, and the government in Florida is trying to act as much as possible as if there is none, because they don't want unions. And of course, part of that corporate labor model is the focus on attacks on tenure. And it's backed up by this kind of narrative that faculty are pampered, they have to be disciplined more, there's too much dead wood, all that old stuff. There's the cost justification, there's the kind of narrative of a need for flexibility, a need for accountability. And we know that these are simply narratives that are really not backed up with the evidence. And so, unfortunately, this corporate model has had a lot of success in terms of what we see nationwide, with only about 30% of faculty generally being on the tenure track line. And now for the remaining tenure track and tenured faculty, the post-tenure review is now part of this continued march by employers, by universities, and by legislatures to try to eliminate or weaken tenure even more. And this fits into that broader corporatization as well of stratification of faculty positions, dividing people into the stars and then the rest of us, non-tenure track positions being filled by people who have continued precarity and who can be simply let go, as people would say, at will. And here, the post-tenure review is a tool that's being used to try to replicate the precarity of non-tenure track faculty through both arbitrary and uneven applications of policies in those post-tenure reviews. So that's the depressing big picture that we're dealing with. And so how do we deal with it? How do we deal with it collectively? I'm going to point to an AAUP report that Tim referred to, the 1999 AAUP. It's called the Post-Tenure Review and AAUP Response, and you can get it easily at aaup.org. Just put in post-tenure review and it will come up. And I think that in that post-tenure review report, the AAUP was emphasizing both the underlying principles as well as some of the practical ways in which the approach to post-tenure reviews can be understood and actually be addressed. And a lot of it's going to echo what Jennifer was saying in terms of what you all are trying to do in the face of this kind of tsunami of attacks on the union and attacks on tenure. And one of the pieces that that report emphasizes is the need to maintain our focus and our emphasis on the underlying fundamental principles of being faculty in a university, that the university has a public mission, and to fulfill that public mission as faculty, we must strengthen the principles of academic freedom, job security, academic due process, shared governance, and collective bargaining. Excuse me. So none of that has changed. Those are still the fundamental principles that need to be put into place. And so even as we try to increase tenure track lines, and even as we try to increase job security for non-tenure track faculty to be kind of a de facto tenure, and we support unionization to achieve these goals as well as shared governance, even as we focus on those, we're still in kind of a damage control mode, which is, I think, what Jennifer was really describing, that in that damage control mode, there are, I guess you would say, let's say, agreements that you didn't want to reach, but some sort of compromise that you felt you needed to. But at the same time, in doing that, I think what's very powerful is that you were keeping your eye on what can we do to strengthen those fundamental principles of academic freedom and academic due process and collective bargaining and shared governance in ways that maintain an integrity around what faculty do in their work and how to protect them in their work. Particularly, I appreciated your emphasis on academic freedom. Because one of the things that the 1999 report by the AAUP points out is that in that report, they say the most damaging aspect of post-tenure review is the way in which it undermines academic freedom. That for faculty, after having gone through a tenure review, to constantly be thinking about how to keep their jobs is to undermine our ability to do our work through academic freedom. It's going to affect doing long-term projects, moving to short-term projects. It's going to be a numbers game. It's going to probably affect many people in terms of their ability and willingness to engage in governance, right? Because with that kind of arbitrariness and the likelihood of discrimination in applying these post-tenure reviews, it will make people more afraid to join collectively in the unions and shared governance and to speak out and engage in extramural speech. And as well as, teaching to evaluations, because that is also going to undermine our ability to really make challenging courses and to actually challenge students to rethink the status quo. So that damage to academic freedom is so deep. And so how do we do that damage control? And I'm just going to mention some of the things that that you already did, Jennifer, and just kind of put them in sort of a list, which I think are so important. One is to recognize that there are already in place evaluation processes without post-tenure review. For raises, for applying for other promotions, for grants, there's a constant evaluation process that's being done. And so, as you said, that you were trying to tie this post-tenure review to what already existed in a way that gives the faculty collectively more control. And so, what's necessary is to use collective bargaining power, put the faculty into the process of developing post-tenure reviews, implementing them if they're going to exist. Number one would be not to have them, but if they're going to exist, implementing them and developing them in a way that is not punitive or that reduces punitive measures as much as possible, but rather to have them be more developmental. Now, that ship may have sailed in Florida at this point, but one can still try to push in that direction and mitigate the kind of punitive nature of the post-tenure review. And then also, as you said, build in a protection of academic freedom for faculty in all aspects that academic freedom applies to. The other thing is this process piece that I wanted to really emphasize. And for any union, whether it's a faculty union or a union in another kind of workplace, one of the reasons for building in due process very strongly is because it really limits what an employer can do unilaterally. And so process and procedures are essential to protect substantive rights, to protect academic freedom, to protect our ability to do our work. We need due process, that an academic due process that requires the employer to maintain its or limit its power so that the faculty collectively and individually have as much say in this process as possible. So the more that peer review can be used and build into that process is essential. The more that the ability to appeal decisions is really well developed, is really important. And then the other thing that I wanted to emphasize in this is, and then of course, before I get to that, the criteria for evaluation, as Jennifer mentioned, to build that in so that it's understandable and workable for faculty to actually have criteria that make sense within their particular discipline. That's also essential. And then the other thing that I did want to emphasize, and that's in the 1999 report from the AAUP, is the issue of the burden of proof. Because what these post-tenure reviews attempt to do is to shift the burden of proof from an employer, here the university, to show that a faculty member is incompetent and should be subject to some kind of discipline with academic due process. The university is now trying to shift that burden to the faculty to prove that they are worthy of being retained. And so the more the original vision of academic due process, of the burden of proof being on the employer, can be maintained and pushed back through the union's bargaining, the more it will also protect academic freedom. So I'm going to stop there, hoping that those suggestions are useful in terms of perhaps solidifying some of the things that we've already heard, and thanks very much.
Thank you, Risa. That was really helpful. I really appreciate that you ended on the burden of proof pieces and the procedural pieces. I've been teaching a class that relates to faculty issues, and one of the things that I've been trying to emphasize when we talk about tenure is that very piece of burden of proof and who has the presumption of continuation or who doesn't. So I appreciate that in all of your comments. I want to remind everybody that we are looking forward to questions from the audience in the chat function. I have a question or two that I can ask, but I would much rather pose the ones that you would like to have answered than the ones that I've thought of. But as you're putting those into the chat feature, I will go ahead and just ask Jennifer to comment on your experience of this post-tenure review process, and to the extent that you can, your colleagues' experience of it, right? So this is you've provided wonderful insight into how you've fought the provisions, how you negotiated better provisions, even though you couldn't get them fully removed. But this is one of, as Risa said, one of a number of legislative attacks trying to deinstitutionalize higher education. And our focus is on collective bargaining and what it can do to protect these things. But I'd also I think it's important for the conversation for those who aren't in Florida to have a sense of what this specific attack on tenure is having on faculty experiences, faculty attachments, faculty views of bargaining, and what the larger attack that it's situated within is having.
Yes, thank you so much. I think some of the effects include and especially in some departments, it's really hard to recruit faculty, and people are leaving. They're not necessarily saying they're leaving because of the politics, but I mean, it was just one assault after another. Not only the post-tenure review, but SB 266 also said no arbitration for personnel matters. And so that's something that we have to deal with as well, right? That there's not an arbitration process for personnel matters, which has not been defined. So that's an issue as well. Of course, the Stop Woke Act. Trying to kill the union by saying we have to have 60% membership every year. I mean, it's just so many things that we had to try to deal with at the same time. Fortunately for FSU, we just found out recently that we were certified again for a year, that we did reach the 60%, but the process starts all over again, making sure, because there's so much turnover, right, that we're continuously needing to recruit, which we should be doing anyway. I'm not saying that, but just it's a continual process to focus on that rather than focusing on bargaining and so on. But we're really lucky at FSU because not patting myself on the back, but I think we have a really strong team that is familiar, knows a lot about what is happening in Florida and how we can try to mitigate it. So I'm not sure if that answers your question, but
that was very helpful, and I think you can pat yourself on the back. I think that so you're referring to Senate Bill 256, which has changed the requirements for union density to 60% for recertification. And as you know, but just in case some of the audience don't know, that after sort of official government employees sort of working directly for the government, faculty have been the ones that have been most affected by that bill, with the non-tenure track faculty unions being decertified. So this is that larger context of attacks on labor, which extend beyond higher education, is really being felt in Florida. There is a question in the audience that I was thinking of asking a similar type question. The question is, many faculty do not see the danger of PTR and academic freedom. And I think that's part of a larger problem that we have in higher education, where many faculty don't quite understand what academic freedom is and what it protects and what it does do. So the question is, how can we drive home the importance of the threat that post-tenure review plays to faculty themselves, as well as to a broader public who may not understand the true importance and value of both academic freedom and the tenure that is needed, or at least is the best form of protection for it. So for either Jennifer or Risa, or even better, both.
Jennifer, I don't know, you want to go first with regard to what you've seen about kind of the fear that people have? Or I could go, it's up to you.
No, go ahead. I get to get through.
All right, yeah. Yeah, you know, my experience as a faculty member, I started as a faculty member in 1982, and my experience over all those years is as we got into the 1990s and then into the 2000s, that there's a general fear that's increased just everywhere. Right. And I'm in a private university, very wealthy private university that, you know, one might think people feel more comfortable once they get tenure. But there's still this generalized fear of opposing the kind of forces from the administration that have gotten stronger and stronger. And it's certainly an increased fear of people who are on the tenure track and yet to come up for tenure. So given that, if we, under circumstances where we're not facing this kind of, you know, draconian post-tenure review, if you then put on top of that the fact that once you get tenure, you never have tenure, you are always having to prove yourself, so that the anxiety that people feel on the tenure track, and I worry about that, right? We need academic freedom to be more strongly protected for those on the tenure track before they go up for tenure. But that anxiety continues forever, and it becomes a numbers game. It becomes about productivity and assembly line vision, which is going to undermine our ability to do our work and to do good work. And it also becomes hesitant work, more fearful work, the fear of offending. And all of that is going to affect the integrity of the work that we do without our wanting to affect it. And there might be, for the broader public, perhaps some very good examples of like discoveries that have been made in the sciences because people had the time to kind of noodle around and fail, right, in certain ways, but then came upon something which would not have been discovered without that ability to be free to be experimenting. And all of the beautiful, you know, literature that comes out, plays that come out of universities where there isn't this kind of pressure to produce. It feels like faculty should understand it, but I agree with the person who asked the question that we also have to educate each other about what academic freedom means inside the classroom, outside the classroom, and what it means to act collectively to protect our ability to exercise academic freedom individually and together.
Wonderful, thank you.
I agree. I mean, tying it to the political interference in education in Florida is, I think, one thing that we've tried to do. But you know, it's also overwhelming, everything that is happening, and people are fearful. They're changing their syllabi. They're changing the title of their classes. They're changing how, you know, what they talk about in class. They are changing like how they challenge students, right? Because students can now also record us without our knowledge. So challenging students, people are fearful about their research. I've heard people talking about scrubbing their CVs from titles that would, I guess, trigger the politicians in the state. Add to that what happened at New College. Again, all the political interference in our teaching and research. I think a lot of, maybe I shouldn't say it this way, but I think some STEM faculty think that it's only just in the humanities, like just the arts and humanities are the only ones that need to worry about it because we don't talk about controversial issues in STEM. However, so right now, the Board of Governors is looking at the list of general ed courses in Florida at each university. And I think it was I think it was something like nearly 400 classes we had at FSU, and they cut it down to 62. How do you filter all, you know, 40,000 students to? 62 courses, I'm not really sure. But some of the courses that were on the chopping block were in STEM, and they were shocked. And so I don't know. I don't know what to do, how to get people more involved, but it does feel overwhelming. I think that's one reason they might not get involved, but also just focusing on the politicization of our work. I always hope that that's going to get people motivated.
Thank you. I think that's right. And I think that when I think about this, I also think about shared governance and the importance of intramural speech for all faculty, regardless of what your discipline is, right? That we have the sort of historic notions coming out of the 1940 statement of freedom in teaching, freedom of research, and freedom of extramural expression. But as Matt Finken and Robert Post have argued so well and for the common good from the very beginning, intramural speech, the ability to criticize your department, your institution, what's happening, is fundamentally important to notions of academic freedom. Tenure is the best protection for that. And without that, Carrie Nelson's argued, it's a three-legged stool of academic freedom, shared governance, and tenure. Without the ability to criticize your institution and to make suggestions and to make thoughtful suggestions, the whole system doesn't work. We have another question that gets to the point that we're focused on Florida and that's where our attention is, but this isn't just a Florida issue. It's a Texas issue, an Indiana issue, and a number of states issues. Some of the framing, that this has been proposed in 10, or versions of this have been proposed in 10 states, South Carolina, one of them, in recent years. So the question is, since this isn't just a Florida issue, what are some steps that we can take writ large to try to counter these attacks on tenure through post-tenure review?
Well, it's always the same answer, isn't it? Right? It's Joe Hill telling us don't waste time mourning, organize. It's always about organizing. Easier said than done, right? But organizing matters, and we have examples of being able to push back on attacks on tenure, but it takes a lot of work to do that. But I think that one of the things that Florida shows us is that once there's an attack on rights, and other states have shown this too, once there's an attack on academic freedom, an attack on our job security, that compromising doesn't help in those early stages. It's the early stages where it's essential to push back harder than ever so that the losses can be as little as possible. But it's not easy to do, but it has to be done through alliances of not only faculty and their unions and their collective, organizations with the AAUP, whether it's a union or a non-union kind of chapter, et cetera, and the national, but also with other unions, with other allies who have an interest in pushing back.
Yeah, the collective action. Oh, I'm sorry. I was just going to say the collective action is essential. I mean, it's just essential for us to work across states, but also across unions, right? Get more people involved. I mean, parents groups should be concerned about what's happening in the classrooms in Florida, right? Like there's in Texas and Indiana and Iowa and so on. But yeah, I think it's all about collective action.
When you were talking earlier about the corporatization of higher education, the first place my mind went to was Adriana Keyser, Scott DePola and Scott's book, The Gig Academy, right? And the broader restructuring of the academic but also non-academic workforce in institutions of higher education to be contingent, to be outsourced and otherwise. And they conclude that book with a chapter that starts with sort of what can be done, and they start with unions as a first step, but the recognition that places like where I am, we don't have a union and can't have a union, and that is a much broader advocacy-based effort is needed that needs to connect those of us who aren't part of organized labor but are affiliated with larger groups that might be to work collectively, and that's hard work, right? Especially it's made harder because of the very things that Jennifer is having to do right now. right? Because of the very things that faculty are having to do, putting together all those materials and changing their work because of the surveillance that they're under constantly. That makes it simultaneously more difficult and more important, right? Are there other questions that people want us to address? I might have missed one or two in the chat, but I don't think so.
If we have a moment, if I could just follow up on something you said, Tim. At Cornell, I'm the president of our Cornell chapter of the AAUP, and we're what we would call an advocacy chapter. But we act like a union as much as we can. Because of yeshiva, we can't obligate the employer to bargain with us particularly if it's tenure track and tenured faculty. But organizing is organizing. And whatever organization that you have, if you have power, you're going to have power. And if you have a law that is supportive, but you don't have power, then the law isn't going to be used as well. So no matter what, we have to organize. And we're also facing, and this is related to all these issues, this crackdown on speech now with regard to these new so-called expressive activity policies. We're facing that at Cornell. Other people are facing that. It's the same kind of attack. It's the same control mechanism, the unilateral control mechanism from above. Governance hasn't been respected to actually deal with this. And this is a matter of democracy. We haven't actually used the word, but these are about democratic rights. And I have to say, I'm really pleased that our AAUP chapter has been really out in front in opposing these kinds of repressive measures on speech. And we've been doing it in alliance with other organizations. And the university, I think, is worried about us in terms of the kind of energy and really strong positions that we're taking. And we're allied with students, with other faculty organizations, with other staff organizations. We're doing that together, and it's about democracy and the governance matters that you're talking about, whether it's shared governance or other kinds of governance bodies and collective bargaining. And it's about democratic rights. Academic freedom is a democratic right. And I think that emphasis of really saving democracy and the way in which higher education is essential to doing that is what we should be emphasizing.
That's wonderful. I think you would fit in wonderfully in the weekly conversations that we have at the center about the perspectives that we have and we need to pursue. And Isaac did mention this early on as we think about these larger efforts of moving beyond people who would choose to log into this webinar, right? We're probably speaking to people who are already thinking and active in these issues. Part of the center's charge is to take the ideas that we're generating through webinars such as this, through our own research, through our own writing, through the larger conversations, and in the second year of the center, really start pushing out materials to a broader public, both within and outside of higher education, to try to change some of the narrative around academic freedom, around tenure, around these core values in U.S. higher education that, as you relate to broader democratic values and are essential for broader democratic values, but that aren't often viewed that way, both cynically by those trying to use the issue to gain political or to extend political power, but also those who just don't think deeply about them and have this notion, whether it's through the media or through not thinking about them on their own, that tenure is just a privileged status, when in fact it is about the ability of universities to do the work that society wants them to do and that they've been doing for so long. There are a number of great comments in the chat. I'm sure we're all reading them, so I'm not going to go through them. Are there other questions that we want to pose to our panelists while we have their time? Well, if not, then I think what we want to do is honor everybody's time. I will turn it over to Isaac in just a moment. But before I do, I really want to thank Risa and Jennifer. I've learned a lot from both of you today. I've appreciated your work on these issues for a long time, and then you're sharing your experiences and your knowledge with us, with all of us here tonight. It's been, for me, a really important conversation. And so I appreciate you taking the time to share your opinions with us. Isaac?
Thank you, Thanks everybody for being here, and thanks so much for Jennifer, Teresa, and to Tim. I've learned just an incredible amount, and am really inspired. I have Joe Hill on my shoulder thinking about academic freedom. And I really loved what Risa said in your compliment to Jennifer about the tapestry of weaving these and how the defense of academic freedom is good unionism and good democracy advocacy, and that we need to both build power and also in the spaces that we do have power to use and be creative and to support each other. So I hope that there are people on this call that learned a lot from the example of FSU and are thinking the wheels are turning about what your bargaining sessions, what your union can do. I hope that people will be in conversation with each other and will be inspired, reach out to us. More than happy to be in contact and to continue the conversation. And we really see this as a beginning of a conversation. And we really look forward to being in touch with everybody who's been on this call. So thanks so much for your time. And thank you, and keep an eye out for the other 3 sessions of the Academic Freedom School Florida edition. I just want to thank everybody who's been on the ground in Florida fighting on these issues. I mean, Florida, this is an absolutely essential fight. The battles that you've been up against, the onslaught, the amount of power and money and resources and grotesque abuse and anti-democratic and authoritarian impulses that you have been withering and weathering have been just horrifying, and the ways that so much creativity and struggle is still coming out of this. And I think that, you know, Florida is the future of higher education, and I hope that that's a future in which we're all fighting back together in solidarity, so that this is an epiphenomenal period and we can turn that tide. And I hope that we can do that together and with continued conversations. Again, thanks so much to the panel, to Katie and Robert for really galvanizing this conversation. And I look forward to being in touch with all of you in solidarity moving forward. So thank you for your time, and enjoy your dinners. So have a good evening.